good afternoon once again. I am quite sorry for my inability to make last week. And, I already arranged for this evening before now, but I realized that late last night that my program is canceled, so I stopped traveling again. So that's why I'm available. So we start. Now, we have gone through the introduction, and then all we wanted them to do was to start discussing, the so I have covered the vehicles of business, that is sole proprietorship, partnership, incorporation. Is that correct?
Yes, sir.
Yes, sir.
Okay, of course. So what we want to not then I have sent the Partnership Act to you, right? To look at.
Yes, sir.
Okay. Yes. Now, so today we are going to be looking at the nature of regulations that cover business relationships. So we will be starting with the Partnership Act. And I want you all to open your act as I speak to them, and then we'll be discussing, those provisions along with the partnership business on its own using this act now, so that you can better understand these things. I will try as much as possible I can before light comes back. Otherwise, we may have to do it again in the evening. Now, so let's go. Now, there are three major types of provisions in any legislation that regulates interpersonal relationships, like you and I, either to do business, even in marriages, and stuff like that, or to engage in sale of goods, to be in business partnership and all of that. So that, or to form an incorporation, to incorporate a company and join together to work it out. So these are the type of examples of legislation that regulates, interpersonal business relationships: the Sale of Goods Act, the Partnership Act, the Companies and Allied Matters Act. So we can stop there. Now, how many of these types? There are three major types of provisions. When you open the Partnership Act, and I want to believe you've opened yours, you'll see, so you will find in there what you call mandatory provisions. Mandatory provisions. And I want you to know these things. Mandatory provisions. Now, what are mandatory provisions? Mandatory provisions are provisions that mandate, that command, that insist on compliance. That is what they are. They insist on what? On compliance. And you have to, and parties must comply with them. Otherwise, there may be penalty, either the penalty to the extent that they cannot enforce that their contract, or the contract is void. So that is mandatory provisions. And there are reasons why some provisions are mandatory. Sometimes it is to protect the public at large, to ensure uniformity in the use of certain phrases or language, or to protect the weaker party, sort of. So those are the reasons why they often come in, because when you are negotiating, you realize that the power play is different. We have different, power relations, even in negotiations. Some have an upper hand, the other one have, like a weaker hand. And therefore, but when you equalize the parties, you can only equalize the two parties in negotiation by insisting on a uniform provision that they must abide by in relation to certain things within the business issues. So, but then knowing the meaning is one thing, identifying them is another. So, to identify a mandatory provision, there's a language that is used in the provision of that law. We talk about shall, the parties shall so do so. Must is also a good indicator of a provision being mandatory. But bear in mind that must is rarely used in legislation. So shall is often common. And sometimes neither shall nor must is used. But in the way in which the statement is made shows there is no, flexibility except to comply with what you are reading. Now, so that is that. Shall, mostly shall, and I've given you why it is that so. Okay. Now, again, you look at definition. Definition. When every legislation has a definition section, we call it definition section. It defines. Okay. It defines, and once that definition is given, it binds. When you state that a particular phrase or word means something, like for instance, a good means, or firm means so and so, and it is defined, you cannot change that definition. So it's also an example in that law that anywhere you have a definition or a statement of law, that binds that binds, whether or not they use shall or they use may. That is standard. So you need to note all of that in terms of the essence of. For instance, if we go to section 4, you to your section 4. Open to section 4. Let's see. Are you okay? Now, if you're in your section 4, I just want you to read. I want someone to read it off for me. Let's look at it. Section 4. Is there anybody there at all?
Yes, I'm trying to scroll down there.
Oh, okay. Let's see if I can.
Is it the one that is at 55, 53, and 54?
No, Section 4 says persons who,
Okay,
the decisions start from number 1. Now, I'm saying section,
okay.
I've given you. Go ahead.
Persons who have entered into partnership with one another are, for the purposes of this act, called collectively a firm, and the
No,
name under which
let me
the
wait. Let me read my section 4, please. Sorry. There is 4 written at the bottom, subsection 1. See, persons who entered, who have entered. Is that the one you are reading?
yes, sir.
Okay. Persons who have entered into partnership with one another are, for the purpose of this, are called collectively a
Collectively
firm,
affirm.
and the name under which their business is carried on is called the firm name. Now, this is mandatory. This is how they will be described. This is how they will be described for those that have entered into a relationship now, and the definition has been given to us. Okay, so it is important that we bear the meaning, you know, in mind. Mind you, there is a separate provision for definition, but you also will see from time to time some words being defined, being stated, as telling what, the parties must take. They cannot change these things. Now let's look at section 1, for instance. A partnership is the relationship. So it's a relation which subsists between persons carrying on a business in common with a view of profit. Now, again, that is a definition of partnership. It tells you that it has to be between persons, persons meaning two or more, and they must be carrying on business, and the common object of doing that business is to make profit. If your relationship it does not fit into this particular definition, then you are not in partnership. You are not in partnership. Okay? So, and it is important you bear that in mind. But these are all, mandatory provisions in, in a legislation. Sometimes if you go to the definition section, you can see, you may see a particular word defined to mean that a farm means, as used in this act, means so, 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 and so. And that simply means that that is how you must look at the farm. That is how it is defined, is binding. Now, we move on to another one, provision type, and that is what I call empowering provision or enabling provision. Now, and I want you to get it, empowering provision or enabling provision. So you can use either empowering or provision or enabling or even optional. What that means is that from the phrases or words I've used, empowering, when something empowers you, it gives you a leverage to do something, either of the parties or both of the parties. If it is optional, it's also a leverage. You may look at this or take the other one. So you have options. It is not binding on you. You can do something else. So that is also enabling. Okay. Now, so when you are enabled, again, you are empowered to do something. Empowerment and enablement is the same when you look at it properly. But that is how these things work, and you get to situations where, parties are enabled that way, right? We are how they are enabled that way. Now, how do you identify, and the meaning of enablement is to, again, ensure that the parties are not tight, are not caught in one corner. They have options in their relationships. They may either do this or do that. So the easy one or way to recognize empowering or enabling provision is use of the word may. The use of the word may. So when we go through all of this today, you will look at this. Just go or read casually some of these sections. You will see the way they are used. Or better still, we document some of the sections that you can look at and see what that means. So enabling provision is identified by the use of the word may. May. Okay. So bear that in mind. And the essence of that is to give parties or the partners flexibilities, either those that are purchasing, or selling goods and buying goods, or those that are in partnership. At the same time, you find a lot of it also among, in the Companies Act, where you see the use of word may for parties, not binding on them, where you also see shall all of the time because they must, comply with what is stated there. Now, the other third one, the third type is what we call a default provision. We call it default provision, default provisions. So you will find this one a lot. Now, default provision is compulsory indeed to be in a legislation that regulates private interactions, default provision. But what is and the significance of this, I will explain. I will explain. And also and pinpoint some of the examples that we have in this act. Okay, I will explain. Now, when you talk about a default provision, I want you to before define it, let me use, an example. All of us all have telephone at a start. When you buy your new, imagine now that this class, we all purchase, a particular brand of telephone. Now, that telephone comes with a default setting. It is the same thing that applies to this analysis or this example is the one that applies to this provision. So bear that in mind. So we all buy when we turn it on, after charging and we turn it on. The setting, all of the setting on our phone comes with the default manufacturer default setting. So and we all understand what that means, that it comes with the manufacturer setting. But coming with it is to show us that we can stick with this manufacturer setting and go ahead. Now, suppose some of us are bored. We don't like the manufacturer setting. Do we have an option? So we do. That is the answer. And having that option means that the manufacturer will enable us to change their own default. Okay? So essentially, there is a setting, which is the underlying rule. What means underlines rule in our discussion? There is a general rule that all the parties are bound by. But just like the manufacturer setting, the manufacturer, and in this case, the legislator, they also give us an empowerment to change that setting. They give us an empowerment to change that settings into the one we like. So which means the initial manufacturer setting is called one size fit all setting. It's a one size fits, everybody has it. But a one size fits all, whether in terms of phone or in terms of law, will not meet all our various circumstances. So it is not always good. And that is why the enablement that comes with the default setting is very important. So what is the role of that enablement? What is the role of that enablement? The role of that enablement is to opt out of the manufacturer setting and customize your own setting. Customize your own setting. But if you don't know how to customize or opt out, then you are stuck with the manufacturer setting. That is how these things work. Okay? If you do not know how to operate opting out from the manufacturer setting, then you are stuck. So which means the manufacturer setting becomes your law, your rule as far as operating that system, that telephone. And the same here with default setting of this legislation. Now, when you begin with your default setting, the rules that you find there is the one you use. But if you recognize that, if you're able to recognize that this is a default setting, so you know that they are asking you, you have been empowered to change this rule if you don't like it, But where you refuse to, or ignorantly you don't know that you can change it, or you may change it and you have not changed it, then that underlying rule, which I call manufacturer setting, will be your own law. Whether it fits your circumstances or not, you are stuck with it and you will live by it. Sometimes such rules, ultimately, if you don't change it, can create problems. And we are going to be seeing those things. Now, but how then, so that is how it works. So a default provision has three components. The first component is the default, is the rule, the underlying rule. Call it the underlying rule. Underlying rule. That is your default setting. So there is a default rule. We call it default rule or underlying rule in the context of law analysis. But in terms of manufacturing products, we call it default setting. Whether your television, your telephone, your computer, they all have underlying rule. But the good thing is the second level of it is the empowerment portion of it. That is, all users of the law or of the product are empowered. They are empowered to do what? They are empowered to change that law, that setting, to the one they like. That is, the legislature has given you a law. They are asking you in a default provision to change that law in case you don't like it, because it may not fit your own taste or circumstances. And if you do not therefore change it, if you do not therefore change it, then you will be bound by that rule, which means there is nothing you can do again. That rule will be your rule going forward. So that is why it is important to understand these things. Now, so the empowerment part of it is key. Now, but then, and then after knowing that there is an empowerment, the next important one is going forward to change it. Okay, to change it, to customize it to the one you like. So which means as regard a particular rule, 10 partners or partnership may have 10 different arrangements because they have changed the default rule. If none of the pockets of partners does anything, they will have one single rule, which is the one that came with the law. The one that is in that section is the one they will be stuck with. So if it's only one person that changes it, it is only that one person that will have a different provision for himself or for themselves, that partnership setting now. The rest of us will be bound by the one that we are crying about, which we could have changed if only we knew. But because of ignorance, we don't know. So how do you identify? So I want you to bear in mind that a default provision is compulsory in relationships among people that are private. So that rule applies to everybody across the board. We recognize that such a rule cannot be effective because the rule cannot bind every situation because the lawmakers are not aware, but they enable us to start our life in relationship from the rule that they can conceive for us. The one they can give us may work for us. But if then, and having given us that one, they also recognize that it may not work for everybody. So they empower you with a phrase to change this rule. There is a phrase that you are given or we are all given to change, to change it. Lawyers understand this phrase because we are taught and we teach our students in practice. But non-lawyers don't understand. But once they see that phrase, they know we can change this thing. So they remind the lawyer, do you have all of the default rules in this particular legislation? Okay, go lawyer, get all the default rules for us and read it to us because you know it is in that one you can customize and have your own imprint in your relationship, not the imprint of lawmakers that are in Abuja who don't even know your circumstances. So the next issue, therefore, is how do we recognize these default provisions. Now, I will use it is, as I told you, phrases. Phrases. Okay. Now, let us go to section 20. 20, or let's see. Okay, go to section 21. So we now want to look at the phrases that is used to give us a default provision. If you're in section, I don't know, let me see whether they have given me the power to share from the other end. Okay, let's do this. Let me share, then I can share now. Okay, if you are looking at this, and let's see, I'm sharing my screen so that you can all look at it. For those of you who don't have the act before you. Now, look at section 21. It says, and this is section 21 here, it says, unless the contrary intention appears. That is one of the standard phrases for default provision. So which means this section 21 is a default provision, and it's going to have a rule. And that rule starts, this is the manifestation of empowerment, unless the contrary intention appears. Whose intention? The intention of the parties, the partners here. Now, that is what they're talking, that unless the contrary intent, that is, a different intention appears from the partners, this will be their rule. Property brought with money belonging to the farm is deemed to have been bought on account of the farm. So, except you have peculiar arrangement, once you have used the farm's money to buy something, it is taken that that property belongs to the farm and you cannot change it. But if for whatever reason the money is given as a loan, you must clarify that this is not supposed to be. It is not, or I mean, although it has been paid into the partnership account, if we are buying something there, then let them know, or let the parties know, your partners know, that until you are paid fully for this purchase, the property will not belong to the farm. That is one example. Okay, that is one example. So if you so so if you are paying, so sorry, if you are in partnership and you have paid money into your partnership account and is on condition, and they have used that money to buy a property, except you define the relationship between you and that property and that of the farm, the law takes it that it belongs to the farm. And the problem is that if you don't know that unless the contrary intention appears means that you can change it, then you run into a problem. You run into a problem that property, you can't take it out. You cannot claim it. And and until you are able to, or except you were able to manifest another intention in writing so that everybody can see it, that okay, you define the circumstances how it came to this, you will not be able to to claim it as your own property. Okay, now then let us go again to section 24. 24. Okay. Now when you look at section 24, it says the interest of partners in the partnership property and their rights and duties in relation to the partnership shall be determined subject to any agreement, express or implied, between the parties by the following rules. Now, this section 24 is saying that the relationship between the parties and their property and everything is set into all these rules. This rule 1, 2, 3, 4, 5, 6, 7, 8, 9, even 10 is there, if I guess. So that is what, Joshua, can you please, because your sin is covering my face. So it's telling us that this this is this is the rule that will govern the relationship between partners. And there are many of those rules. But it tells you that subject to any agreement, express or implied, between the parties. So which means that subject to any agreement means that these are the rules that will govern you partners. But you have the enablement to use your agreement to change any of them, and customize it to the one you prefer. Now, that is how it works. But overlook, if you overlook it and you didn't change any of these things, then what you are reading here, this rule, like the factory setting, will bind you. And when it binds you, it may not give you happiness. It could only give you regret or annoyance, and that is how these things work. For instance, let me read the first rule. This first rule is one of the underlying rules that you can change. And if you don't change it, you are bound by it. It says all the partners are entitled to share equally in the capital and profits of the business, and must contribute equally towards the losses, whether of capital or otherwise sustained by the firm. So this rule says that the partners are entitled to share capital, at these assets of the firm and the profit equally, and they must also share the losses equally. And I think I mentioned these things some time ago when I started this thing. Now, this rule is telling you that subject to your own agreement, that is, you may change it, but if you don't, this is the rule. And then you have a situation in which you have two partners, A and B. Now, when they contribute money towards this partnership, one contributed 20 million, B contributed 10 million, and there's a profit of, say, 15 million here now at the end of the year. So this law says now that it is time, or a loss, that's a loss of 10 million. Now, this one says that if you do not change this law by your own express agreement, this is the rule. You will share your profit equally. You will also share your losses equally. That is what it's telling you here. Equality. Okay. Now, when you are contributing money towards the business, somebody has made 20 million contribution, the other one is 10, and they have it 15 million. Now, if they do not change how they are going to share this profit, it means that both A and B will divide 15 million into two, making 7.5 million. That will be the default rule. But for parties that are contributing differently, this particular rule cannot serve their interest. So the rule is telling you through this, subject to any agreement. We have seen the other one, 2021, except contrary intention appears, subject to any agreement between the partners. So it's telling you that you can override it. It's an empowerment to override this particular rule to give you the kind of peace you want. And in this circumstance, the type of peace you will want is the sharing formula of profit that recognizes, that this man will take twice as much as the other gentleman. That is what it means. It cannot be equal. It cannot be equal. So if you divide, so so to be able to share 15 million, you must ensure that the man that contributed twice will get twice of the other guy. If you fail to, out of ignorance, to change or define the distribution that will override this, you will be stuck with equal sharing of profit. And this is where problems start with the parties. It isn't because they are not good people, but the trap, which is the help that the legislature is giving to them, they refuse to understand what it means. They didn't change it, and therefore they are running into argument, and hotly fighting. Look at number two. The farm, that is, unless you change this particular second number, that's how you read it. Unless that is subject to your own partner's agreement, the rule is that the firm must indemnify. You can see it's talking about must. That is, it's become mandatory. The firm must indemnify every partner in respect of payments made and personal liabilities incurred by him. Now, what this means is that unless you know unless you create a different agreement, the firm must indemnify every partner in respect of payment made and personal liabilities incurred by him. So if you pay money on behalf of your business, or you indemnify, or sorry, if you pay money on behalf of your of your firm, the law entitles you to indemnification or to indemnity. You'll be indemnified. That is, your money spent on behalf will be returned to you. That is and that is fair game anyway. I don't think parties need to change this, except there is background circumstances why there will not be indemnification, because it is possible that the firm has also lent you some money. And so if you are paying, that money should cancel out the loan you received. But if there is no documentation about about the loan, and that you make it clear that if you commit your personal funds, towards the firm, it will be taken as if you are paying the firm back. So if there is no record that you have paid the firm, if there is no agreement that this particular thing must not be interpreted as it is, particularly if a loan has been taken by one of the department that is paying now, because then there will be indemnity. And the partner will tell, the other ones will tell you that, but we that there is something that we have given to you, you haven't paid. If you pay now, which means you are just being a very conscientious partner. And the other person says, no, the law says you must indemnify me because I paid it for the farm. Okay, so that is just what this means. And that is why it is sensitive for you to understand all of this. In the ordinary and proper conduct of the business of the firm, or in or about anything necessarily done for the preservation of the business or property of the farm. So if you spend money either under circumstance A or circumstance B, you should ordinarily get your money back, except you have given your own circumstances, it cannot remain there, so you change it. That is what we are talking about. Now, look at this one. A partner is not entitled before the ascertainment of profit to interest on the capital subscribed by him. So sometimes, you have made contribution, and this second is telling you that no partner can claim interest on that capital, until you have ascertained, the profits. That is, and you can only ascertain profit when you have gathered all your expenditure and knocked it out. Because by the time you knock everything out, it may be that there's nothing really to give back to you as an interest on your money. Ideally, it should be taken as a loan, but it is not a loan. So if you are going to insist on that, there must be an agreement that spells it out to be able to change the coloration of this no interest being paid. On its own, some of the rules that the legislature gave is good. Some may not fit into their circumstances. That is why these rules, they have thought it out that these ones will govern, they regulate the partnership and stuff like this. And that is how it will be used for the partners. So, but if the partners then feel that it is not really ideal, then they have to change it. They have to change it. If they don't change it, they will run into problems. Now, and I want you to go through this section 24 in particular. Those are the rules that govern partners. You will see as you read that some of these rules are not true in real life, though not fair in real life if you leave it that way. Now it says, no partner shall be entitled to remuneration for acting in the partnership business. If you are acting in the partnership businesses, there is no remuneration. But you ask yourself, but I undertook it for the benefit of everybody. Why shouldn't they give you your money back first before they talk about, at the end of the year, you have undertaken some expenses or expenditure on behalf of your business, and it's not just your business alone, and it's a lot of money. So because you have not you have not agreed that whatever you pay on behalf of your partnership business will be paid you back. This law says if you do so, you are not entitled to get remuneration. So these things are difficult to chew, but if parties or partners understands what they are doing, they will change all of these rules. First of all, these are all changeable rules or variable rules or replaceable rules. But you can only replace what you know you can replace. Otherwise, ignorance will prevent you from even understanding it. Okay, that is why we are taking, as I said, similar regulations of default provisions of empowerment. You also find in other laws like the sale of goods. We all buy goods back and forth. Those provisions are also there. Okay, so no person, okay, no, and then look at number 7. No person may be introduced as a partner without the consent of all existing partners. So you cannot bring anybody in without the consent. So if you are going to bring somebody in, there must have been an agreement between the partners that you can't do it. Otherwise, you cannot do it. Okay? Now, I will take you to, I'm trying to go over all of this, but at the same time, you have to also take your time to read these things. This is a classical example of default provisions. We saw one in section 24. We saw one in section 21. Then you go to section 19. If you go to section 19, you see, this is what 19 says. The mutual, section 19, let's see. The mutual rights and duties of partners, whether ascertained by agreement or defined by this act, may be varied by the consent of all partners, and such consent may either be expressed, inferred from a cause of dealing. So whatever your rights and your duties as partners to a business, this law says those rights may be varied. The mutual rights and duty of partner, whether it's the one you agree by a document or the one that this law, states out for you, it is telling you It is telling you that you must, oh, sorry, that you may vary it by the consent of everybody. By the consent of everybody, you may vary it, you know. And when you vary it, what it simply means is that you are changing those rights. So for everybody who wants to be partners, you go to someone to, "Oh, can you help us prepare a partnership agreement?" So the person that is helping you must take instructions in the knowledge of these provisions we are talking about. So because you have a right to define your relationship in an agreement, the law also has also given you some definition to your relationship. Section 19 is saying that you may change it or you may vary it by consent of all partners. And that consent must be either clear consent, express contract, or in fact from conduct or course of dealing. This is how we have changed it since last year or since 2 years ago, and we are stuck on it. So it is understood that you can change your your relationship, your duties, and your rights as you define it by this act or by your own agreement. That is a provision of empowerment. That is enabling. This section 19 is an example of enabling provisions. Section 19 is an example of enabling provisions to allow parties, to relate to one another. It enables you to change your agreement anytime you want, but it has to be with the consent of everybody, every partner. Okay. Now, if you look at introducing, look at section 12, for instance. Section 12, section 12. Now, if you read this section 12, and I want you to look at section 12 and see whether you can classify it as either mandatory or enabling or default. I know it might be difficult, but you can always try. We are here. Say every partner is liable jointly with his co-partner and also severally for everything for which the firm, when he is a partner therein, becomes liable under either of the two last preceding sections. So every partner is liable jointly, with his co-partner and also severally for everything for which, while you are a member, of that partnership, you know, the partnership becomes liable under either of the last two sections. Two sections meaning section 11 and 10, liability of the firm for the wrong. So section 10 defines it, section 11 defines it, and for anything that happens either here or there, this section 12 tells us that you are jointly liable or you are also severally liable. So how do you classify this one now? Anybody that can hazard, is it mandatory to you? Is it enabling or is it a default provision? So,
It, hello, hello,
yes,
sir.
sir. Yeah.
It is a mandatory provision, sir,
Why
that
do you
they
say so?
jointly, because it states that they jointly bear the losses and they also jointly bear the
Severally.
profit as well. Yes, sir, severally. So it's a combined provision that binds the partners, sir.
Okay. Okay. Thank you. That is
Yes.
correct. And I really
Yes.
must give you credit, because this one, I told you much earlier that when the law used the word must or shall, it is mandatory. I also noted that there are cases where none of those words are used. But when you read what it says, there is no room for you may not be bound or you may be bound by something. That is what happens here. That it says every partner is just stating the law here. It's not giving any leverage of or entertaining the possibility that you can change it or whatever it is, at least this particular one. But remember that this is creating a duty and a right. This section is creating a duty and a right. But remember, we read in section 19 that whatever duty or right that this law creates for you, you are empowered to change it by agreement. So it is for the party. So the quality of partnership you have depends on the quality of knowledge you or your lawyer has about partnership law. That is the simple thing here, that there is so much leverage created. But the question is, do you know? Do you know those leverages? Can you take advantage of it? If you don't know, you'll just be sitting down there. But if you know, you have a very active, very vibrant relationship because everything has been taken care of through negotiation. And that is why the more knowledge of relationships you have, that or anything that undergird relationship, the better for your relationship. It will survive. It will be efficient. There is no quarrel because anything that could have caused a problem has been taken care of. That is justice. But a lot of people may not know, but it is important. Now, you can see section 10. It says, where by any wrongful act or omission. No, sorry. Let's see. Okay, let's already read 10. Section 10. Let's see. Okay. Now my battery is running low now. But let's look at 10. Where by any wrongful act or omission of any partner acting in the ordinary course of business of the firm or with the authority of his co-partner, loss or injury is caused to any person not being a partner in the firm, or any penalty is incurred, the firm is liable therefore to the same extent as the partner so acting or omitting to act. That is, if you engage in any wrongful act or omission while you are doing the work of your partner, the partner is liable. Also, your firm is also liable. This is what we call vicarious liability. So that is what this one is saying, that you will be liable, under section 12 we saw. Then 11 says, in the following cases, namely, where one partner acting with the scope of apparent authority received the money or property of the third party and misapply it, and where a firm in the course of its business received money or property of the third party, and the money or property so received is misapplied by one or more of the partner while it is in the custody of the firm is liable to make good the loss. So that is just, this is the law. It is mandatory, just as under section 10. Anything that is happening in 10 and 11 is mandatory. It's telling you what will happen in these circumstances to the partners. But again, as I said, if you may not know in law enough because of time to be able to understand the relationship with other partners to enable you bring forward a very cohesive system. Now, I want you to now I want you to look at section in introduction of new partners. Let's see. Partner admission. Okay. So let's see. Now, if you look at section 6, it says an act or instrument relating to the business of the firm or done or executed in the farm name or in any other manner showing an intention to bind the farm by any person thereto authorized, whether a partner or not, is binding on the farm and all the partners. When you undertake to do something, in the farm's name and stuff like that, then whether a partner or not is binding on the farm and all the partners. So whatever is done, patently on behalf of the farm binds the farm and also the partners. Now, so what I want you to do is that now sections, some of the indices or the indicia of a particular provision. If you are looking for mandatory provision, you must look for whether the particular section is defining a situation for the parties, not giving them any opportunity to change, no leverage. It is mandatory if there is no leverage in the section, in the language, but whatever gives a leverage can only be either enabling provision, just as we saw in other sections like section 19. And there are other enabling provisions there. Or you can also have a leverage in default provision, so just as we saw in section 21 and section 24. These are all provisions that we need to understand. If you're able to understand these provision types, you know the advantages and the role they play, the role the lawmakers want those provisions to play in your relationship, and you act accordingly. But if you do not know, then you will just be doing things as if they do not affect you, but they do affect you. It is because you know it is because you don't know. Now let's look at section 15, and I want someone to interpret it for me in a provision type. My Let me just warn that there have been no light, so this one I only have 10% of battery, so I will just continue and then maybe at some point. But that is what really I want to teach, this provision type and relate it to partnership, since we have discussed partnership, the need for partnership to. Yes, Okoya. Once you know, just continue. Don't wait for me to call you. Just start talking because of our time. Okay. Go ahead. Somebody raised up. I said, section 15. How do you classify that section 15? An admission or representation made by a partner concerning the partnership affairs and in the course of his business is evidence against the firm. How do you classify this?
Good morning, sir. So I think it's a compulsory action that should be stated and taken. Provision. Yes, sir.
Mandatory. You did
Yes, sir.
mandatory provision. Yeah.
Mandatory. Yes, sir. I
So
feel
why
it's
do
a
you say?
mandate. Okay, because if it is not itemized, anybody will just do anyhow, and there will be no structure at all, and anybody can just take money as they wish, and the business may crumble. So for there to be orderliness in the firm, in the mode of operations of the business, it is mandatory that this provision is stated clearly for everyone to see and to understand.
Okay.
Thank
Now,
you.
thank you very much. You are correct. But the trigger here for me is that it said an admission or a representation made by any partner concerning the partnership affairs and in the course of partnership business is evidence against the firm. It's telling you that if any of these things happen, it constitutes an evidence against the firm. So it is fine that if any partner admits anything or make representation to third parties in relation to the business, it is taken to be against and true for the firm. Nobody can deny. That is what makes it mandatory. Okay. Now, notice to act. Okay. Now, look at 17. Again, can somebody quickly look at section 17 for me? Really, what we should be looking at, given how these things are to be understood, is your own, time. Given where I am on my system now, you might have extra time, but spend that extra time to see whether you can identify, 10, each, whether you can identify 10 sections that you can classify as enabling, as mandatory, as default. Having done some practicals with you, I want you to also, because you're being able to do it mostly is enhanced, when I'm not with you. But when we come back, you can then, at least explain, or I mean, you can go over the ones you have done and we can correct it and stuff like that. So it's very important. Now, I had originally said that I would teach this evening, and your class captain was able to get your buy-in. If you do not mind, because as I said now, I've only done 1 hour. We should be doing 2 hours. If that allowance is still work, I can come back by 6 o'clock. We do 1 hour, 6 to 7, and then we can close it so that we can do a little bit more, much more than the time, because I don't think my system can go for another 1 hour as it is now. So do I get a buy-in from here that it is still possible to meet in the evening? Anyway, let me leave it for the class captain to negotiate that.
Shall we continue?
Yo.
How about Joseph? Now you be the host.
Yes, I'm sorry.
Now you be the host.
My brother,
Hey,
you're on your own.
you are your own.
Good afternoon, guys. Please, can you mute your mic?
See you guys at 6.
I have date night. It's date night, baby.
Okay,
Cynthia,
you
not
just
this
plug
very
in,
advert.
plug in headsets. I
I
be,
The
mean,
I
6
be what
p.m. one has not been
hands free.
confirmed.
I hear you.
Ladies and gentlemen, see you at 6.
I want to suggest that they postpone it till later in the night, too. Some of us will still be somewhere.
I say,
Exactly. I think that 6 p.m. is too early because that's when some people will be on their way home.
Let's
7,
do
7:30
7,
would be
7,
ideal.
7,
Yes,
exactly,
by then
7
they
to
are
8.
home. Yes, by
That
then
will
they
be
are home.
fine.
They are settled. Yes, because some
I'll be
people
in
might be on
transit
the way.
then. Yes, you're right. 7. Please,
So please,
let's
cost rep, put that
7 will do.
to
Cost rep is not even here.
I think he's here. Is he not Eno?
He
Eno is
was
here
even
now.
asking for class captain. He's not asking for course rep.
I will still be on transit also by that time. Let's just do it 8 to 9.
Mm,
Better.
Or
Yes,
even
I
9
support
or
it
even
tonight too.
or even 9 to 10 safe.
Okay. Chiamaka now. Is it not Chiamaka? Who is the cost rep?
no, it's
He said he needs
best.
class captain,
Eno.
not
Best
course
that's it.
rep.
Best is here now. Abia, she left. She was
Mm,
here now. She was
she's
here
the
when we
one.
were 45. Okay, so maybe we'll reach out to her on the platform and let her know that 7:38 is ideal for us.
Since
All
it's an
right, see
hour,
you.
that will be fine. Is that Mrs.
Mm,
Okafor?
yes, it is me. Oh.
Okay, well done, madam.
All right.
Okay,
By
we'll
your
talk
friend,
outside
Jamie.
this. Yeah, thank you.
What did you
Yeah.
say?